I have something that I think is really important for everybody to take a moment and listen to, because we are finding more and more people that wish they would have had this information long before this problem comes along. And it has to do with how you transfer your property if someone passes away. And unfortunately, too many people don't have this important information and have not put the proper things in place that will actually save you money, time, and a whole lot of headache. So let's begin. When a loved one passes away in Texas, one of the first questions families have is, how do the real estate gets handled? I'm Missy Stagers, broker owner of MStagersRealtyPartners, and I just wanted to briefly walk you through what happens when a property needs to transfer after someone passes away. The process depends on two main things: whether there is a will and how the property was titled. Very important to have a will if you can. If there is a valid will, it must be filed with the probate court in the county where the person lived. The court appoints the executor named in the will and issues letters of testamentary. This document gives the executor legal authority to transfer or sell the property. If there is no will, the estate has to go through probate as an intestate estate, and that's going to cost you a chunk of money. The court appoints an administrator and determines the legal heirs under Texas law before the property can be transferred. In some situations, though, this is the important part, probate may be simplified or even avoided. For example, if the property was owned with the right of survivorship, ownership may automatically pass to the surviving owner. If a transfer on death deed was recorded, cheap to do, the property can transfer directly to the named beneficiary once the death certificate is filed. If the property was solely owned and no transfer tools were in place, probate is the typical required to clear the title. Once proper authority is granted, a deed is prepared and recorded with the county clerk in the county where the property is located. Every situation is unique, and having the right team in place makes all the difference. I always recommend working with a qualified probate attorney and a trusted title company to ensure everything gets handled correctly. More importantly, if you have questions about any part of the real estate process and you're pre-planning, we're here to help guide you through it to the ability that we can. I also want to give you some examples that most people don't understand. If somebody is married, then they own the property 50-50. If you don't have the proper things in place, like a will, right of survivorship, or so forth, then if you have any heirs, meaning children and so forth, then guess what? The other 50% is theirs, and that has to be rectified. Again, another situation that gets even more sticky. Two people are married and they had previous marriages and previous children. That gets even more complicated unless you have these things put in place. And unfortunately, so many people don't realize that, and the surviving spouse then finds out that some ex-wife's child now has 50% right to the house she thought she was going to get to stay in. That's just one example of many. So please take our advice. If you want to talk it through with me, please give me a call. We have some great attorneys we can refer you to as well. And I call this a public awareness statement. It's so important. Thank you for joining me, and we always appreciate you being our past client.